You might be in the middle of a separation or divorce. Or maybe you're just trying to understand what comes next. First, let me say this. This is hard. Whether the split is mutual or not, it's emotional, disorienting, and often overwhelming. One of the biggest stressors, figuring out the financial side, especially what's considered shared property. In this video, I'll walk you through what that means in plain language. What's typically included, what's not, and why it matters. My goal is to help you feel a little more grounded, a little more informed, and a little less alone. Hi, I am Sally, a licensed financial advisor. Let's get started. What is shared property? Think of your relationship like a garden you planted and tended together. Over time, you both contributed, maybe in different ways. One of you might have earned more money, while the other might have supported the household or raised kids. But together, you cared for the same plot of land. Anything that grew during the marriage, whether it's financial or physical, is usually considered shared. In most Canadian provinces, this would include the family home, savings, investments, and pensions, cars, furniture, electronics, and even debt like credit card and loans. It doesn't matter whose name is on the account or the title. If it was planted and grew during the marriage, it's generally considered shared. This isn't about tracking every dollar, it's about reorganizing that garden that was cared for together. What is not shared? But not every plant in the garden is considered shared property. These are often considered separate property and may not be divided. Some of these include gifts or inheritances received personally, assets that you owned before the marriage, some personal injury settlements, and occasionally business assets that stayed separate. These things are like seed that you brought in before the relationship, or that was just given to you and only you. However, it is important that if you plant those seeds in the shared garden, they can become shared. For instance, if you inherited money from your grandmother and you used it to pay for the down payment or mortgage or renovate a shared home together, then that inheritance might now be considered partially or fully shared. So if you want something to remain separate, it has to be clearly kept out of that shared garden. Married versus common law. Here is where things get a little more complex. Not every garden is treated the same under the law. If you're married, there are usually very clear provincial laws that say the garden should be split equally, regardless of whose name is on what. But if you're in a common law relationship, the garden isn't automatically shared. You have to show that you contributed to planting, watering, or tending in order to get a fair share. And this varies by province, and it's often more complicated. This is why it's so important, especially for common law couples, to talk to a family lawyer who understands your local law. Why the separation date matters. The date of separation is like the end of the growing season. Up until that point, everything is added to the garden is usually considered shared. But after that date, what's planted or harvested is usually separate. So if one of you racks up a huge debt or wins the lottery after the date of separation, it likely will not be split. Marking that date clearly, whether through a written agreement or mutual understanding, is key. It protects you both as you move forward in your next chapter. Equal doesn't always mean identical. Now, let's talk about the garden that gets divided. The goal is usually equal value, not identical items. This might mean one person keeps the house while the other get a bigger share of the savings or pension. The law looks to balance the overall value of what each person receives. And in rare situations, like a very short marriage or significant hardship, a court might decide that an unequal division is actually more fair. But that's not the norm. Fair doesn't always mean the same. It means thoughtfully working towards something that's honoring that was built and what is needed to actually move forward. Don't go through this alone. Gardens take time to grow and take a lot of wisdom to divide. You may be feeling tired, hurt, confused, or just numb to what's happening. And that's completely normal. This isn't just a legal process. It's untangling something that you've built with your heart and energy. So please don't do this alone. A family lawyer can help you understand your rights. A financial advisor can walk you through what's best for your future. And sometimes even one meeting can lift a huge weight off your shoulder. You deserve that kind of support. So here is what I want you to take away. If the asset grew during the marriage, it's likely shared. If you brought it in or received it personally, it may be separate. Marriage and common law relationship are treated differently. The date of separation stops the growing season, and a fair division looks at the overall value, not who did what. You tended something real. And even though the relationship is changing, you still deserve clarity, fairness, and peace. This season is hard, but know that you are not alone. You can move forward with wisdom, support, and hope. You've got this. And if you're looking for more support, we've created a free resource just for you. Check out our downloadable financial guide for Canadians who are suddenly single. It is full of practical tools, checklists, and emotional support to help you move forward with confidence. You can find the details in the description box below. If you have questions or want to speak with someone, feel free to reach out for a free consultation with the details in the description box below as well. See you next time.